Good afternoon, everyone. As Julie mentioned in the chat, the meeting is live streamed, and hopefully a few more people will join us. And so rather than have that interruption, let's just wait another minute or two and give folks some time before we get started. Thank you. Okay, why don't we go ahead then and get started, and hopefully others will join. I did get a message from a few folks that they're unable to join this afternoon's call, but as I mentioned and Julie mentioned in the chat, it is being live streamed and recorded. So for those folks that are unable to join today's meeting, they'll be able to watch the video. We'll also try and catch people up one-on-one if we can. In the meeting today, we're going to be sharing the second half of our presentation of findings, looking at data analysis and takeaways from our focus groups and interviews on the use of out-of-home placement, as well as the provision of services for kids in the juvenile justice system. And before we get started, I want to turn it over to Representative McNamara and Senator Kreider for any opening comments or remarks.
Well, I misjudged my time zones, so I am in the car still heading north. My dog refuses to sleep, so I just want to say thank you to everybody again for your participation in this important work, and I'm going to let Nina or Mike get to it.
Yeah, I'll join Wendy in thanking the folks that have participated, provided feedback and input that have helped CSG put this data together. I think the information is not necessarily surprising, but it is nice to have the research done in a way that validates what's happening in Indiana. And so thank you all for your participation thus far.
Great. And instead of doing like a formal or traditional roll call, I think we're just going to take note. We see who's on the screen and compare that with our task force list. And that way we can just go ahead and get started and have as much time for discussion. So I'm going to share my screen and get started with the presentation. All right, let's see if I can figure this out. There we go. All right, can everybody see that? Someone will be moderating.
Yep.
Okay. So as I mentioned, we are going to be talking today about the use of out-of-home placement as well as services for kids in the juvenile justice system in Indiana. And for the presentation today, we looked at three main data sources. Three agencies provided statewide data on youth in the juvenile justice system. We analyzed data from the Criminal Justice Institute, the log of juveniles held for the 19 juvenile detention facilities that exist across the state of Indiana. That's a database that documents the use of these facilities for youth to ensure compliance with federal regulations. And we were able to look at statewide data, unlike I think in the last presentation where we were able to look mostly at just those 12 Quest counties. We also looked at data from the Department of Corrections, which provided data on admissions, releases, and the standing population of youth that are admitted to the Department of Corrections custody for a commitment or a diagnostic assessment. And then we looked at data from the Department of Child Services, which provided data on placements as well as community-based services for youth that had a juvenile delinquency or a juvenile status case. All of the data that we analyzed from these three sources included information from 2016 to 2019. Similar to the last presentation, we excluded findings from 2020. As you all know, there are a lot of operational changes due to COVID and obviously the impact of COVID-19 on the use of placement and other parts of the juvenile justice system. And so we excluded that date from our findings. In addition to looking at data, we were able to engage in additional focus groups since our last task force meeting in September. We engaged in focus groups with juvenile probation officers from a number of different juvenile probation departments. We engaged in a focus group with detention leadership and line staff from a couple detention facilities. We were able to have focus groups with leadership and line staff of the 3 secure facilities through the Department of Corrections, Pendleton, LaPorte, and Logansport. Focus group with public defenders, a lot of different staff at the Department of Child Services, including the youth service bureaus, as well as additional groups of youth through Voices in Indianapolis, as well as youth on probation in Grant County. And all of that information, again, like last time, we synthesized into 5 key takeaways that we'll be sharing data on today. I'm going to pause like I did last time at the end of each section in case folks have questions to clarify some of the data for discussion, as well as to hear from you all your reactions to the findings and to the data. So the first takeaway is on the use of detention, and that youth in Indiana are detained for non-public safety reasons, and that detention is being used as a sanction for probation violations and as a dispositional option. I'm going to start each section by also providing some information on best practices and research, just to set the context and the foundation for the data that we'll be presenting. So here, what are some best practices in how to use secure detention for youth in the juvenile justice system? Reserving detention only for those kids that pose a direct risk to public safety or are a flight risk of prosecution. Making sure that kids are not in detention for non-public safety reasons, using validated screening tools to inform decisions around detention, and helping provide training and policies around how those tools should be used, establishing a robust continuum of alternatives to detention in the community that are matched to young people's risk and needs, and eliminating the use of detention as a sanction for probation violations or for misbehavior, as well as part of a young person's disposition, unless a young person is at imminent risk of harming others. They're a true public safety risk. So what did we see in terms of the use of detention in Indiana? Overall, kind of similar to the trend we saw in the use in how kids are coming into the system, the overall decline, the shrinking of the juvenile justice system in Indiana. Here with detention, we see overall cases resulting in secure detention having declined 16% since 2016. And that's for all cases, as well as the different ways that young people can come into contact or result in secure detention. And I'll describe or define those a little bit because I think it can be confusing the way it's coded in the data. So youth can come into contact with secure detention pre-adjudication before an initial hearing or before they're adjudicated and disposed. That went down 15% since 2016. Youth can be placed in secure detention as part of their disposition. That's the post-adjudication commitment line, and that has declined 28% since 2016. And then lastly, youth can be in detention as a result of a sanction for a probation violation, or they're awaiting modification of their disposition and they're being held in detention at that time. And that's post-adjudication pending. And that declined 32% since 2016. So again, overall, we are seeing a decline in the use of secure detention, similar to the decline we're seeing in overall referrals to the juvenile justice system. We were also able to look at a comparison of JDAI counties and those counties that are not part of the JDAI initiative. For those that are not as familiar with the Juvenile Detention Alternatives Initiative, there are 33 counties in Indiana that are using that approach, as well as a number of jurisdictions and states around the country that are using the JDAI model. And the JDAI initiative is intended to reduce the use of secure detention and to create alternatives in the community to serve those young people pre-adjudication. And here, what we were able to do is look at the 12 counties that joined the JDAI initiative in 2016 and compare that to all of the counties that are not part of JDAI. And we used 2016 rather than all JDAI counties because we felt that those counties that joined in 2016 were just at that point starting to utilize the JDAI philosophy or approach. And so we could better see the immediate impact of what that approach could have on the use of secure detention. And what we saw is that the 12 counties joining the JDAI initiative in 2016 saw about a 50% decline in their detention rates compared to no change in the non-JDAI counties. And that's cumulative because you can see on the slide that top line for non-JDAI counties that there was a dip in detention rates from 2016 to 2017, then an increase in 2018, and then another small decline in 2019. But cumulatively, from 2016 to 2019, those counties saw no change in their use of detention compared to the JDI counties that joined in 2016, which saw a 50% decline in their detention rates. In looking at the use of pre-adjudication detention more closely, we saw that over half of pure pre-adjudication secure detention use is due to a misdemeanor offense. And that proportion has remained unchanged over time. You can see there the different line or bars for each of the years that the proportion in the use of pre-adjudication secure detention for misdemeanor, felony, and status offenses has pretty much remained the same over time. And you can see, in addition to the pre-adjudication detention being used for misdemeanors, about 5% of pre-adjudication detention is for cases that are status offenses. And that is something that we heard also in our stakeholder interviews, that detention in some counties is being used as a consequence or as a sanction for kids that are committing truancy or other status offenses, that they're being sent to detention for a weekend or as a punishment. In looking at the use of secure detention post-adjudication, in 2019, there were over 1,100 cases of secure detention being used as a sanction for probation violations or as a disposition. You can see on the two bars on the bottom, 630 cases detention being used as part of a disposition, and over 500 cases in 2019 of detention being used for a sanction for probation violation, a technical violation of supervision. And what we know from the research is that secure detention should not be used post-adjudication for any of these purposes unless the youth is posing an imminent risk to public safety. Going further into those cases that are being used, where detention is being used post-disposition, we saw nearly 2/3 of cases resulting in secure detention as a disposition are for misdemeanor offenses. That's the first two bars at the top. About 66% being used are misdemeanor offenses for those detentions that are for a commitment or as a disposition, I'm sorry. And for those cases resulting in detention as a probation violation or for a probation violation, a little over 60% are for a misdemeanor offense. So again, these are kids ending up in secure detention post-adjudication for misdemeanor offenses and not for felony offenses. In looking at age, we saw that more than 160 cases resulting in secure detention, and this is for pre-adjudication and post-adjudication, are for kids ages 12 and under. You can see here, even some kids as young as 8, 9, and 10 ending up in secure detention in 2019. And we saw also that about 60% of cases resulting in detention for youth 12 and under are for misdemeanor offenses and 8% are for status offenses. So again, really young kids ending up in secure detention for lower level offenses. And what we know from the research is just one day or just that intake process of getting into secure detention can cause a lot of trauma and result in a lot of long-term consequences for young people. We also took a look at length of stay for kids in detention pre-adjudication as well as post-adjudication. You can see here that more than 38% of pre-adjudication detention cases have lengths of stay that are 3 days or shorter. About 18% actually have a detention stay of less than 1 day, which poses the question if these kids need to be in secure detention in the first place. If they're being released so quickly, they're probably not a public safety risk. Are there better alternatives in the community, such as emergency shelter, the use of electronic monitoring, or could these kids even be released back home rather than having that trauma of being placed in secure detention for those 24 hours? We also saw that nearly 18% of cases pre-adjudication are in detention for longer than 30 days. And what we know is that detention facilities, the structure of these facilities are often meant to be short-term in nature. And so having kids in detention for longer than 30 days prevents them from getting access to services or treatment, that longer term service or treatment that might not be available in a short-term detention facility. The goal is to get these kids out and get them access to those services as quickly as possible. In looking at detention length of stay for post-adjudication cases, and this is for those cases that are in detention as a disposition, more than 30% have lengths of stay that are longer than 30 days, and even some cases where kids are there for upwards of 90 days. We know that in statute, as part of disposition, young people can actually be placed in secure detention for up to 120 days. And similar to what I just said for young people there for a long period of time pre-adjudication, these are probably your more serious kids where it's taking longer to resolve a case that probably need that access to more intensive treatment and services that are not available in these short-term detention facilities. In looking at detention policies and practices statewide, we know that they vary pretty significantly across the state in how they reflect research-based approaches. Counties vary in how they're using a detention screening tool to inform detention decisions. While some counties are using the JDAI tool or the IAS detention tool, we know that there are a number of counties in Indiana that are not using any screening tool to inform the use of secure detention. Currently, state statute allows for broad discretion in how detention can be used. And so therefore, it's not surprising to see that youth are being placed in detention for non-public safety reasons. And when we talk to detention leadership and other stakeholders, we heard cases where young people are being placed in detention for protection or risk of self-harm. We particularly heard that for females or victims of human trafficking. A lot of young people ending up in secure detention for mental health issues or kids that have suicidal ideation. And we know that that's probably not the best place for those young people to get the needed services to help address those issues. And also times where parents refuse to pick up the child or there might be domestic issues at home, but again, not necessarily a public safety issue. We also saw that the availability and use of alternatives to detention in the community and how those alternatives are being used varies across the state, including the use of home-based supervision and services or electronic monitoring, the use of kinship care and emergency shelters. the way those are being used and the availability of those alternatives vary significantly from community to community. Additionally, we know that all of the issues that we just described can contribute to young people being placed in detention initially. A parent maybe at first not wanting to pick up their kid, or another caring adult not being able to be identified to pick up their child. And so these kids are placed in detention, but then released very quickly, 1 or 2 days later. And again, we know that that can result in trauma and other negative outcomes for young people, including mental health issues. We also know that detention facilities in Indiana can have different governance structures. Some are under the authority of the court, while others are structured under the county government. And what we heard from stakeholders is that depending on that structure and who's in leadership, there's a variance in knowledge or the use of research-based practices. And often the rotation in leadership, whether that's county governance or court leadership, can result in changing philosophies and therefore different approaches in the use of secure detention. Additionally, we heard from a lot of stakeholders that the use of detention for different reasons and the different populations that may end up in secure detention can make it challenging for facility staff to fully address the needs of young people. So we heard about some of the structural limitations, particularly in smaller detention facilities, where young people are mixed in terms of their housing units or in programming, boys and girls being mixed together, young kids and older kids, kids that have committed varying degrees of offenses, pre-adjudicated youth with youth that have been disposed of a particular offense, can end up in a similar housing unit or program together. And we know from the research that we're not necessarily addressing young people's needs, and we can actually make young kids worse if we're exposing them to more criminal behavior, or kids that have committed more serious criminal behavior. We also heard from stakeholders that there's been an increase in the number of young people that are placed in secure detention that have more intensive behavioral health needs, and that short-term detention facilities may lack the appropriate treatment to support these young people. And so there's a need potentially to have these young people being served in other capacities where those treatments are available. Additionally, we know that the legislature passed last session the addition of direct file youth into juvenile detention facilities, and that is currently going into effect. And so we heard from stakeholders about the challenge that that provides or presents to facilities to try and rethink how their programming and facility structure can be modified to support young people that are now going to be in detention for longer periods of time, because we know that young people that are charged as adults often are awaiting trial and await their disposition or sentencing longer than young people that are in the juvenile justice system. So before I go on to the next key finding, I'm going to stop sharing my screen and see first if there's anything that I missed or that my colleagues, Emily, Josh, Stephanie, want to add. And then I'd love to turn it to Representative McNamara and Senator Kreider for their reactions, and then open it up for discussion. Josh, Emily, Stephanie, I can't see you all on my screen.
Yeah, I guess I just want to emphasize and highlight that slide that showed the difference in detention usage between JDI and non-JDI counties. And I know folks in counties might have different feelings about JDI, and so it's not to make a sort of JDI is good and anyone not involved with JDI is bad, but the broader point around, in the last couple of years, the juvenile justice system has shrunk. At the same time, there are potentially more serious kids, but one set of counties experienced literally no change in the number of kids coming to detention, and another of counties experienced a 50% reduction. And so what's the difference? And I want to highlight this because it's going to be a theme throughout the presentation. It's come up in many of our discussions that often the reason given for kids being placed out of home is kids have complex needs, a lack of service alternatives, a lack of resources. And I think to some extent what the JDI County experience shows is, yes, those counties get a little bit of money, but they certainly don't get a lot of money. But they have a policy goal, and they had intentionality and commitment around that policy goal. And having that, the resources, the creativity, the alternatives, the using data to drive who ends up in detention, the commitment around not placing kids for public safety reasons shows pretty dramatic outcomes in a relatively short period of time. And so just as this task force continues to think about and we get closer to having to make some determinations around potential statewide policy change, there are real challenges to talk about, like resource differences in rural communities versus urban communities and kids with complex needs. But I think what that data attests to is that Indiana, if it wants to, can commit to a policy goal as a state, and with some even limited resources can experience some pretty dramatic improvements and reductions in terms of keeping kids in the community.
Senator Kreider, Representative McNamara, any initial thoughts that you want to share before we open for discussion?
I would just say, as a legislator who's been particularly interested and concerned about behavioral health issues and how we address those issues, the data to me is concerning, because it certainly appears that we're using the wrong system to address behavioral health challenges. And so I'm very interested in what the people that work in the system have to say about that, and ideas and suggestions about ways that we can improve that experience.
I agree with Mike in a lot of those things. And probably the one you went over quite a bit was just the number of kids that are being placed in detention that are not necessarily a risk. That's a concerning piece to me. Just looking at the number of kids that just for a status offense, or probably the one that stuck out the most is the 1 day rate for me, but I'll let others chime in. I've made it to my destination, so I'm gonna be in and out.
Obviously happy to answer any questions about any of the slides or the data as well, but any other kind of more reactions to the data? What has stuck out? Does it resonate? Obviously, I know, Nancy, you probably have some things that you want to share from the JDI perspective. So if you want to go first, but also would love to hear from others.
Actually, I wasn't going to mention JDI because I think that it's pretty clear from the data that there is definitely an impact and insights that are implementing that model, and those that are not yet doing so. One thing that struck me, and I commented on this at the last meeting of this group, was the age piece, and the fact that we are securely detaining youth, according to this data set, I think as young as 8 years old. And that just strikes me as an area ripe for some kind of change that is bothersome on lots of levels. The other thing that I noted was the data on length of stay post-adjudication, and I'm curious about that, and it really is just more of an observation, because especially there's some really short-term stays well, now I'm going to mention it. At JDI counties, we use our decision point as disposition instead of adjudication, so it seemed like there were lots of admissions to detention, or I'm not sure if they were staying longer post-adjudication, but then there was just a chunk of youth who were staying a relatively short period of time between adjudication and maybe disposition or something. And I'm curious about that. What would need to happen within a week that couldn't even either happened at the adjudication point or why were they staying post-adjudication but predisposition? So that's something that's swirling around in my head. And the other thing was, I think in one of the key findings pieces, you talked about how there are youth who are being securely detained if their parents are either unable or unwilling to retrieve them. And there is actually a statutory prohibition against this. Youth cannot be securely detained for that reason. If they are to be detained, it has to be in a non-secure facility, like an emergency shelter care or something. So I'm very curious about that too. And I don't know if that's a point of education for those who work in the justice system, but there is already a prohibition against that in statute. So those are my kind of 3 highlights from the data slides. Thank you.
Yeah, and Emily, I know you're on here somewhere. It's hard to see where people are. I think that was confusing to us as well, like kind of in the data and how it's coded, like what does post-adjudicate, what does that mean, like that in between time? I don't know, Emily, if you have a better like definition or explanation than I gave about what that really means.
Well, there were 2 post-adjudication categories. So there was the post-adjudication commitment and post-adjudication, which was a violation pending modification. And I mean, I don't know much more detail about how that functions in practice. One clearly seems to be a dispositional option, but how the other one functions, I'm not sure. There might be somebody on the call who knows more about it than I do.
And just because it says, this is just like, I think a definitional issue, just because it says post-adjudication pending doesn't mean that that was post-adjudication detention. Those could be almost all post-disposition detentions. It's just that's how the data is coded, and based on the feedback that we have, that is what we suspect. That, as Emily mentioned, post-adjudication commitment, that is disposition, that is detention being used as a disposition, which, as Nina mentioned, is a practice that most other states around the country have largely eliminated because detention facilities are not meant to be treatment facilities. So that's something for this group to consider. And then post-adjudication pending, as far as we can tell in our conversations with the data folks, is largely post-disposition, kids being placed in detention because of a technical violation of probation. And that's also something for this task force to consider. Many states, including a number of states recently, have moved in the direction of eliminating the ability for jurisdictions to detain kids simply because of a technical violation. The logic oftentimes is if kids largely can't be detained for those behaviors, if they weren't in the juvenile justice system, should kids who, whether it's because of a truancy issue or incorrigibility issue, should they be able to detain just because they're already known to the system? And so that's a policy conversation for the task force as well.
This is Bernice. I mean, starting, I guess, with the good, it was good to see your slides that between 2016 and 19, it looks like overall there's a reduction in referrals as well as detention overall. So that's good. You know, I just echo what everyone said. I mean, including what Nancy said last, just about how really disturbing it is to think of these young kids, as young as 8, being detained. I mean, and I guess the thought I had immediately when I saw that slide, it's like we're conditioning our young people to be in the adult criminal system. You know, get used to being locked up, get used to being handled this way and being in this system. And I know all of us want to see, you know, less adults in the system, right? But it's so baked in that kids who start in this vein end up in the adult system, that our IRS, our you know, pretrial release tool asks, how old were you when you were first arrested as a risk of flight and other issues. So it's just troubling. So thank you, CSG, for your work in sharing this. And I really look forward to the policy discussion of how do we stop this? How do we reduce our system being used in such a hurtful way that will have ripples into future generations for all of us?
And thank you, Bernice. I also saw Judge Graham posting a comment in the chat box about post-adjudication pending, could also be kids pending placement. So we do hear that a lot too, of kids that are in detention for longer periods of time because they're waiting for a bed to open up, whether that's in a Department of Corrections facility or in a residential treatment center. I don't know, Emily, if you were able to take a look at that in the data, or if that was just categorized like as part of this big category of pending.
I think I will kick it over to Andrew, who did the detention analysis at this point. But I will say that the way that the ICJI had defined the categories was first the commitment being the dispositional offense, and then the pending being specific to, I'm just looking at, it was a previously adjudicated youth who is subsequently adjudicated for a violation of probation. So it's kind of a category specific to probation violations, and then their pending modification. So that's how it was defined from the information that we received.
Okay. Andrew, I see you shaking your head. Okay.
I'm sorry.
Sorry, no, just to David, go ahead. I said, yes, that is what we see in the data, is that, or not in the data, but in our conversations with stakeholders as well, that kids can be in detention longer for that reason. I'm sorry, Justice David, go ahead.
Just quickly to clarify, sorry, Justice David, to Judge Graham's comments then, it is not kids who are awaiting placement. It was kids who are specifically placed in detention because of a technical violation. Now, they might get subsequently committed based on that technical violation, but it was kids detained just for that reason. Sorry, Justice Dave.
No, not at all. I won't go into the details as to why I'm interested in learning some Swahili, but all I've learned so far is pole pole, which is slowly. I think that's the translation. And so that's sort of been kind of how I've been tuned into this is let's look at this. This is all great and helpful. I'll modify that slowly, pole just a little bit, because I see, for your consideration, our policymakers, our legislative friends and allies. I really want to hear from the boots on the ground, the Bernices and the Chris's and the Judge Grahams, and those of you that are actually involved in these decision-making matrix and as a result of that. But from my used to be a subject matter expert in this area, I really see a couple things for the group's consideration and for our leadership's consideration as it relates to policy and legislative initiatives is, what is it that could be done policy-wise or statutory-wise to enable, or maybe even urging court rule or whatever, that would make that number as it relates to JDAI counties even better, right? Or column 2, what is it? What are the first, second, third, fourth steps as we move forward that could be done policy-wise, rule-wise, legislation-wise, partnership, collaboration-wise, to take the non-JDAI counties, as we're focusing on detention, right, drop that number significantly. And so I think it was mentioned, the young, very young entering detention and that being a policy decision. So I think there's a number of opportunities that this presentation clearly identifies, not just to help those that are doing better than others, but to help everybody and make the system better. I know, at least it's been my experience in the past, that some detention facilities, many detention facilities, have done a tremendous job of providing additional educational opportunities and treatment opportunities just because they had no other choice, because we didn't have the adequate services available elsewhere, geographically or cost-wise. And so as we think big picture and focusing and moving those services or creating those services, the hubs, some of the conversations, the block grants we talked about, we've got to make sure we plan that accordingly so you don't have this big gap in services, because some of these facilities have had to default to do that. My last point is I think there's another really, 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 really good opportunity to focus on that 1 day in detention. If that is truly 1 day, meaning probably an overnight, right, Judge Graham? What are the most common circumstances? And it may be, that child is suspected of or clearly being trafficked, and you don't have any other place to put that child. And if you let that child out, they'll disappear. But if that's the case, what can we do about that? Or where is this happening? If they're in detention 1 day and we review that and they need to be in detention longer, that's a separate, but that seems to me a real opportunity to make significant progress, because what that tells me is probably anecdotally, they didn't need to be there, right? But we didn't have any place else for them. So to your point, Nina, and your associate's point, and what I think we all agree with, if they're there one night and they shouldn't have been, but we don't have a better choice, and we need to fix that, because that exposes them and puts them at high risk, just like putting that 8-year-old. I mean, surely we can find someplace, something, or some means by which to keep that 8 or 9-year-old, unless there's some sort of serial killer or mass murderer, but still we got to separate them, right? So I'm very moved by this, and I think there's a lot of opportunity for our legislative friends and our policy friends or our judicial friends to kind of say, okay, what would be best for you? What would help you the best? And both those sides, not just the non-JDAI counties, but the JDAI counties, because I think it's clearly that institutionalizing policies and procedures, the risk assessments that we mentioned that must be done and aren't being done some places, we need to fix that. And maybe that's our obligation to fix that. Our legislative friends shouldn't have to do that. We just need to do our job. But I thought this was fascinating and really, really, really an opportunity. So it's frustrating and it makes me sad, but it also is like, okay, this is great. We can do something about it. So I'll shut up. I would like to hear what my friends have to say.
Yeah, no, I really appreciate your comments, and like you, would love to hear from some of the practitioners and people on the ground who are making these decisions, because it's not to say that people are doing this to harm kids, right? I think a lot of times people are putting kids in detention because they think they're protecting them or getting them the services that they need, right? If a kid is at risk of harming themselves or they're being trafficked, we want to protect kids. But what we know from the research is that we're actually having the opposite impact in terms of placing a kid in detention. And so we want to empower people and give them opportunities to make more research-based decisions with how to get better outcomes for kids. And we're not saying, you're doing this because you're trying to harm kids intentionally. It's actually the opposite. So I know, James, you had your hand up, and then would also love to hear from Christine and Judge Graham and others.
Thank you so much. I guess I am boots on the ground, all the way on the ground compared to everybody else. I think I just have a statement and a question all wrapped into one. If the data across the state of Indiana shows a decrease in juvenile detention, but yet some of the data that you showed in the past shows that there's an increase in certain categories in violence, and it also shows a disproportionality with African-American, Black and brown kids. So those cities or those places where there's an increase, maybe misdemeanors and lower level offenses where they're not rising once again to the level of public safety. I'm going to go back to what the judge just said. There has to be a middle ground, because on the grassroots level, we're drowning, we're dying. Kids are dying, kids are getting shot. And these are kids that are not really they haven't hit the system yet, but they're on the verge of getting to the system. But some of the schools have done a good job of doing our best as teachers and administrators to keep them out of the system. But the communities in which they live in are just falling apart, and the parents don't have a clue. there's no respite. There's no middle ground before these kids get to the juvenile justice facilities, or if they come for one day, their offense may not rise to the level of public safety, but it doesn't mean that creating hell, on a lower level. So when you talk about the second and third graders, I had a family the other day who has a third grader, and he's just hell on wheels. We've tested him. We've done everything under the sun. And we can see a pattern that this kid's aggressive behavior is going to lead him somewhere, school to prison pipeline, but we're doing our best to keep him out. So there's a mentality that the parents right now, I was just in Gary this weekend in a neighborhood that I grew up in, and I got young kids who are offending, but not at that high level that will have them locked up in the juvenile justice facilities for weeks, months. So it's kind of somewhere in between. And, that in between level is the level that I think parents are looking for help, because there's no scare straight. We don't do that anymore. You can't drop them off at RSR. There's no respite where a kid can get some assistance, and the parents with the kids can get assistance, because mental health counseling is a volunteer type situation. The kids and the parents jointly have to agree to go. It's like making a horse drink water when the horse doesn't want water. It's really tough to get a defiant kid to the well. So it's almost like that kid has to commit an offense before the family can get some help. And that's why, we talked about, no, the system is not a good place to refer kids for help. But a lot of our families are saying, well, we have no other recourse. So that's where I'm at. It's a question, yet it's a statement. I'm kind of perplexed by the data that says, and we want detentions to go down, but there's a rash of violence. For instance, when I go back to school next week, I have 22 waiver hearings of kids who are being recommended for expulsions. Now, we don't expel a lot of kids in Warren. We do everything that we can to keep them in school. So we've had close to over 100 recommendations for fights, gunshots, and unlawful activity in the community. The violence level is rising to a degree to where we don't know what to do. And our interventions at the local level, it's almost a moot point. So where's that middle ground at? Where a kid is going and they're detained for 1 day, 2 days, and then they go back into the community and all hell breaks out, and they probably won't be on your radar again for a while, but eventually they'll get to your radar. How do we collaborate as a school system and the courts to kind of help each other get to a middle ground? I guess that's my question as we move forward.
So I think the good news, those are all significant challenges that, as we work with jurisdictions around the country, is a real struggle. And there are no easy answers, but as we'll present in one of the sections, resources are actually not the problem. In many places, it is a lack of dollars and just a lack of resources. I don't think that's Indiana's challenge. And Nina will sort of go through how some of the dollars at the state level are being allocated. The question is, how are those dollars used? And are they used in a collaborative sort of way to create a continuum of options for kids? And I think not to say that those JDI counties don't have some of the issues you're describing or others have described with violence and maybe some lack of supports, but it shows that even as the entire state is experiencing certain trends, that's declining referrals overall. So part of the reduced use of detention is just less kids coming into the system, but also increasing violence. Some communities have been more creative about how those dollars are used or what kind of tools are used to create different kinds of alternatives. And I think it speaks to Justice David, your point about, so like, what are the options? And generally the magic formula that other states have used is policy requirements plus dollars. And that one without the other doesn't work. So you can say, use a detention screening tool. You can't place kids for non-public safety reasons as Senator Kreider mentioned, detention's not the right place for kids who are at risk of self-harm or have other behavioral health issues. But if there are no dollars or infrastructure to support those policy requirements, that's not a successful formula. On the flip side, though, states have also found you can make all the dollars and resources and tools available, but for a variety of reasons, some jurisdictions just won't kind of, as you were saying, drink that water. And so while you want to allow for local discretion and customization and empowerment, some at least floor requirements, and folks have talked about a number of them that states have used, is setting a minimum age of detention and just saying you can't detain 8-year-olds or 9-year-olds or 10-year-olds, and we're going to figure out as a state what the alternatives are. That you need to develop policies like kinship care policies and behavioral health diversion programs and school-based diversion programs so that kids don't end up in detention for one day for an issue that probably could have resolved if the policy supports and the resources were there to prevent that youth and they could go to respite or other things instead. And so I think that again, there's no easy answers to any of these things, but for this group to consider both sort of a floor level of policy requirements that people feel is what the state should commit to without overreaching and still allowing counties to lead this work, and how dollars can be more intentionally used to support those policy requirements so counties are not left sort of hanging out there by themselves and trying to come up with those kind of middle ground options.
Christine, I saw at least that you turned your video on. That might mean that you have something you want to add to the conversation. If not, I'm calling on you anyways.
Voluntold. No, thank you, Nina, because so many of the comments you've all shared, I shared the same and have make notes. And with the services subcommittee that we'll be working on, I'm very passionate about the linkages to the opportunities, as James was talking about, for the parents that don't have many options until the system does become engaged. Diversion opportunities, I think at the front end are really a strong focus that we could look to recommend and move forward. To keep them completely out is important, but so much for me is related to the right youth getting connected to the right services at the right time, which for many of us, we are the last stop. So it's the engagement that we will have. So I think that's important. And I think just moving forward, I think so much, and Josh just basically stated what one of my comments was going to be, policy directives often guide how we have to rethink how we do our work. And that takes courage to push that out there and say, this is what we need to look at, because we know the evidence and the research says this is what will work best or has worked best in other locations. So I think it's everyone's insightful comments. I absolutely agree and look forward to digging in to see what we can develop as recommendations.
Great, thanks, Christine.
I would say in response to, Justice David's questions about, what are these, practically speaking, those making the decisions, what are these one-day detention times? How do we have these kids that are so young being detained? And often when I see the one-day detention, well, sometimes it's because we can't find the parents to release the child to, or we can't find a guardian or someone who has legal authority within that first 24 hours. And so it counts as a day in detention. I think the dual status legislation was really helpful in forcing the delinquency side and the child welfare side to really communicate with each other and work on some of these issues with these kids who are dual status youth. I mean, they're involved in both sides. Sometimes the one day is the kid has said, I can't go home because there's some sort of abusive or neglectful situation. So that has to be quickly investigated. Oftentimes too, especially if it's a sex offense, it's scrambling around and trying to find an alternative, safe way to place that child where there's no other children that they might have access to. So if it's, for example, perpetrating on siblings, you're not, you really don't want to send that child back where those victims are. You're looking for grandpa or grandma or an aunt or uncle. I mean, there's a lot of reasons why you might have that one day detention that nobody likes to have. but you got to figure out what to do with the child in that 24-hour period. And I do think that unfortunately we're seeing younger and younger kids committing more serious offenses, and they're with their parents, with other adults or older siblings, and it's I hate to, I like the idea of let's not send any kid under than X age into a secure detention facility. But what's the alternative? I think that, and that's part of our conversation here. So I just would say one other thing I notice is really a lack of awareness, because sometimes we could divert some of these kids using things that we already have, but everybody doesn't know about them, like the Children's Mental Health Initiative, or, community partners, or even, family preservation services, just coordinating. We would have the ability to do some things differently, but not everybody knows. We have a constant rotating door of young, inexperienced. Sometimes it's their first job ever. They may not have any experience with children or working with families, and it's that it's hard to keep everybody aware of all the things that are out there that we could already use. So don't forget to look at what we already have when we're trying to revise the system as a whole.
Yeah, and that last point is a really good one, because that is something that I heard a lot, for example, around emergency shelter care, right? Like that there is availability in a lot of jurisdictions, but it's not necessarily being used for certain purposes. And maybe the lack of understanding or knowledge that those resources are available and could be used for certain reasons is something that needs to be taken a look at in terms of the breadth of alternative options, what exists, but also some of the policies behind using those for this purpose as an alternative, and you can't use detention for those reasons as well at the same time.
I think it's also, as we're talking about policies and resources, important for folks to keep in mind that usually when we work with states around significant policy changes, depending on what the change is, it often doesn't go into effect right away. There's often like a year or 6 months or 18 months of a delayed effective date to be able to work out some of these implementation issues. So, Judge Graham, for example, how does more knowledge and resources get shared statewide about what those opportunities are, where there are more rural communities where there is no emergency shelter or local capacity? How can counties work together? How can other systems work together to help fill those gaps? So I know some of this can be sort of intimidating and thinking about gaps that exist in the system, but the policy requirements and the funding are sort of, if you put those out there, then you can get people around the table, smart, creative people, to figure out how to deal with some of the necessary implementation challenges. But requiring folks to do that hard work is an important first step.
Before we move on past detention, any other comments or reactions or suggestions that folks want to make before we continue?
Hi, Nina, this is Chris. Yeah, I mean, we're talking about lots of challenging balancing of interests. And I think the state has done a great job in recent years, working with JDAI, just, looking at those numbers. So, I mean, I think we've got a good success story to tell. And that was, primarily through policy goals. And I think that policy goals are very important. And with, kind of the interaction with state and local government, how do you help local stakeholders see the benefits of certain policy goals and continuing to work on that? I think that's really important. And, particularly with the nonviolent first-time offenders, right? We have lots of things that we can do through policy goals. We also share the level of concern with this, the increase in violence among teenagers and children. And so sometimes those issues, are going to take precedent for victims, the family members, people living in the same house. And I think as Judge Graham highlighted a lot of those reasons, some of the context behind some of those numbers. So, and so knowing the alternatives, I think, is really important. If, doing that gap analysis on what does non-secure detention look like, from county to county, and what are truly the alternatives. But that's, along with accountability for parents. And I don't know if we've talked much about that, but that's a challenging thing too in this picture as we move forward with policy goals. But those are, just some of the highlights from my perspective. And, the individualized determination on each one of these decisions, the data is helpful, but the mere fact that someone was detained for a misdemeanor just tells a portion of the story. What sort of previous contact was there? What does a risk assessment look like, if there has been one, for the risk of danger or flight, in addition to a number of factors that went into that judge's decision. So I think, it's a complex set of interests that we're all trying to balance.
Thanks, Chris. Yeah, I think that there are a lot of good points there that you made in terms of seeing what the breadth of alternatives are available in community versus community across the state. I know, at least from my conversations, I spoke with communities that had a wide range of alternatives, and then there were others that had secure detention or released home, and those were really the only two options. So identifying those gaps and seeing where they could be strengthened, I think will be really important. And then obviously the local state balance is something that I know that we're talking about in each of our working groups, is kind of how do you create a straight statewide structure, but then have local control or local innovation, local flexibility, local control over policy decisions and so forth. And having that balance, I think, is something that we're engaging in conversations with in all of the working groups as well, whether we're talking about detention or diversion or any part of the system. Josh, I see you about to.
Yeah, I was just going to add, appreciate Chris's point about when you only look at the presenting offense, that's kind of a blunt criteria. And it's where a detention screening tool can be so useful, is because the point of a detention screening tool is to include only those factors that research has shown relate to risk of reoffending or flight risk. And so right now, for counties that, as Nina went through, have various kinds of criteria, various kinds of validated tools, that isn't the consistent basis by which counties are making detention decisions. And so the ability of the state to consider statewide requirements around the use of a detention screening tool can be really valuable, not just to enforce that public safety standard, but also from a data collection perspective, to be able to understand then statewide who's getting what kind of results on that detention screening tool, where are kids ending up, and then what kind of alternatives need to be put in place to support kids who don't score as detention eligible. So agree that there can be more of a story there, but it's why a lot of states have gone to kind of a mandatory detention screening tool, is that those include a lot of those different factors.
Yeah, and the only other thing I was gonna say to address some of Chris's points is, and also James, in terms of an increase in violence and the concern around violence, which is valid, given a lot of the data we see around the country in the last year, at least, not necessarily a trend over a long period of time, is that a lot of the policies that we've been discussing with the working groups and with the task force are meant also for folks to be able to really prioritize that population, because that is the population that is most concerning to communities and to public safety, is trying to figure out how to deal with that population of young people that are cycling in and out of the system, that are more violent or committing more serious offenses. And to do that, we know that the system has to prioritize its capacity and resources on that population. And in order to do that, you have to kind of think about other ways to serve the lower risk population so that you can focus on that higher risk, more serious population. So that is something that I think is a priority, whether we're talking about the front end or how we're using placement as well.
To address the question that appeared in the chat, in our last presentation, when we were looking at the referral data for the 12 Quest counties, we saw where we did see some increases was in felony weapon cases and misdemeanor weapon cases. Those are both relatively small categories, so it's not a lot of kids. The felony violent or person offense category was fairly stable, though it did technically increase from 1,011 in 2016 to 1,102 in 2019. So a tiny bump, but pretty much stable. But in the context of most other referrals declining, so the proportion of cases that you're seeing for felony and violence did tick up a bit.
Thanks, Emily. And Joel, I know you had put another comment in the chat around fines and fees, and Justice David, you just responded to that. You know, I know that the interim committee, I'm going to get the name wrong, Courts and Corrections, Courts and Criminal Code. One of the issues that they're focusing on in this interim is around fines and costs for juveniles in the system. We did have some of that data that we were able to analyze from the Quest counties, and we shared it with the committee, and hoping that that can be something that's addressed. But I don't know, Joel, if there's something you wanted to say also at this meeting about that, because it is an issue that young people are getting, or there are costs associated with being placed in county detention facilities.
Yeah, so the data that I was able to pull from the Odyssey counties over the period that I pulled was, it was nearly $900,000 were being charged to families when we're talking about county-based costs and fees. But when it was a DCS reimbursement, it was less than $10,000 that families were asked to reimburse during the same time period. And the distinction there is going to be those per diem fees for detention. And I think it's going to primarily, so I also noticed that several of the counties in the top 10 were counties that did not have a detention center. So I think it's the need to try to recover those daily per diem detention costs that's driving a lot of that.
And that data that we shared with Joel and with the interim committee, we can share with the task force because it was analyzed as part of this task force's work. But we didn't want to duplicate efforts knowing that the interim committee was focused on that issue. And so we weren't going to present the actual data in a presentation, but we will share that information with this task force so they have that available. Any other last comments or reactions around detention before we move on?
Yes, I just wanted to add to, there's some discussion around the use of emergency shelter care, and just wanted to make everyone aware that as part of the Juvenile Justice and Cross-System Youth Task Force, which is a permanent task force of the Children's Commission, I currently co-chair that with Judge Galvin. There is there was a still is a subcommittee that specifically looked at, they initially, without any data, thought that we needed to expand opportunities for emergency shelter care, but the information that subcommittee was able to get was that on any given day, shelter care facilities are about 50% full. So there may not be necessarily a need for additional bed space, so to speak. But what they also found was a couple of things. One of those things was that the emergency shelter care facilities have the ability to say no to admitting a youth. So there are several facilities, if a youth has an allegation of, I'm going to just battery pending, they deem that youth to be aggressive and will not take that youth in the emergency shelter care setting. However, many of those situations are what Judge Graham described, like it might have been an intrafamilial conflict that led to that charge, and is that youth really at risk of aggressive behavior in that setting? And so there were some recommendations made to the Children's Commission around training and education for shelter care facility staff and those kinds of things that could potentially open up bed space that already exists, but opens it up in terms of eligibility to some of those youth.
I'm sorry, one crazy idea, since we're all among friends, and maybe this is already being done, I just am not aware of it, but collectively, let's think outside the box and you know, is it possible that we can at least move the needle by thinking about creating some portals, some technology assisted ways to match up? I mean, if Nancy's saying at any point in time, it may be a geographic limitation, there's a 50% availability. You know, are we expecting DCS or probation or other service providers or people involved to run through their checklist? Is there a way that we can technologically advance and make some of these decisions or locations easier, thereby reducing some of this? I don't know. This may not be the right forum for that, but if anybody thinks that has a strand of anything positive, just share that with whomever might. But I think it's important. I really appreciate the value of just listening to other people sharing their perspective and being able to spin the head, and your heads are a lot smarter than mine. So anyway, that was just something to think about.
And there are states that have tackled either statutorily or administratively both things that got brought up. So Nancy, to your point, there are states, whether it's in statute or administrative rules, that have established no reject and no eject policies for residential providers, that if you're gonna get state dollars, you have to serve the population of kids who need your services. And so you don't have a choice, which helps to address some of the capacity issue. As we'll talk about in a minute, there does seem like there's plenty of resources being put around emergency shelter care. So that might be a policy opportunity for this group to consider. And to Justice David's point, there are states that have created kind of online service registries or service matching tools to try to help with folks identifying where there is fallow service capacity across the state that kids can be connected to. And so we can share examples of that as well.
And I just have one more comment, because I just have to say that as part of that group, that subcommittee group who made those findings, they actually did recommend, and it was implemented by DCS, a online site where folks can go and check for which shelter care facilities are taking what kind of kids and that kind of a thing. The issue right now is that it's only available to FCMs on the Chin side. We're continuing to work to make it available to probation officers with some enhancements that are being made to have a bed availability ready at the fingertip. So that is actually something that is in the works, but because it is on a DCS site right now, probation officers don't have access, but we are working on that.
Great, thanks for sharing that, Nancy. Okay. I am going to reshare my screen, and we're going to move on to some findings around commitment to Department of Corrections. Okay, so our second big takeaway from the data that we analyzed, this is data from the Department of Corrections, is that youth committed to DOC custody consist largely of moderate risk youth. And there are some youth with low-level offenses that are also being placed in these secure facilities. So again, starting with some of the research and best practices around the use of out-of-home placement, we know that out-of-home placement should be reserved for youth that have the highest risk of reoffending or that require inpatient, more intensive behavioral health treatment. That validated risk and needs assessments, as well as behavioral health assessment, should be used to inform dispositional decisions. So that information should be shared with all parties that are part of that decision-making process. that lengths of stay in placement should be limited, and only the time should be only that is necessary to provide the appropriate treatment for young people and to mitigate their public safety risk. Family engagement in the use of out-of-home placement is definitely important, making sure that families are engaged in case planning, in the delivery of services to young people in placement, as well as youth that are reentering from commitment. And that developing robust reentry plans should start upon entry into a facility, and they should provide for the continuity of care to address all of the youth's criminogenic needs and other needs for them to be successful in the community. So again, kind of similar to the trends that we're seeing in overall referrals, the trend that we just saw overall with the use of detention, Indiana saw a 34% decline in commitments to Department of Corrections custody between 2016 and 2019. And the state saw a decline in each of the different types of commitment. So whether a kid received a new commitment, that was a 31% decline, a recommitment for youth that committed a new offense while on commitment, and that was a 42% decline. And those youth that violated their parole, a 33% decline. And we'll talk more about reentry. You can see that parole violators, that number is low, and that is because not a lot of youth in Indiana are actually on parole once they are released or discharged. In looking at the offense profile of young people that are committed to Department of Corrections custody, more than a third of DOC commitments in 2019 were for misdemeanor offenses, and that's pretty consistent over the last few years. And less than half of those misdemeanor commitments are for person or weapons offenses. So you can see, for example, 2019, 37% misdemeanors, 63% felony offenses for DOC commitments. In terms of risk level, we looked at data that Department of Corrections provided on the IAS risk assessment score for youth that are admitted into Department of Corrections custody. And we saw that 60% of commitments were assessed as moderate risk to reoffend, and a little bit more than a third were assessed as high risk to reoffend. So again, here we see young people with misdemeanor offenses as their most serious offense, as well as moderate risk youth ending up in the deepest end of the juvenile justice system. When looking at length of stay for Department of Corrections, this was actually interesting data. You can see in the table kind of the significant increase in 2019. Overall, the length of stay, the average length of stay for youth in DOC custody increased nearly 67 days between 2016 and 2019. There were small increases from year to year, and then a large increase from 2018 to 2019. We also saw that the average length of stay for youth, whether it was for a felony or for a misdemeanor, average length of stay increased regardless of the offense profile. But as we expect, the average length of stay for youth committing felony offenses was approximately 26 days longer than for those committing misdemeanor offenses. But again, the length of stay overall increased regardless of the offense profile. Each year, about 100 admissions to Department of Corrections are solely for the purpose of receiving a diagnostic assessment, which is a practice that most states around the country have eliminated. So in Indiana, youth can be court ordered to receive a diagnostic assessment in a Department of Corrections facility prior to disposition. In 2019, over 60% of diagnostic intakes are for misdemeanor offenses. When youth are admitted for a diagnostic assessment, they stay approximately 3 weeks. But during that time, they're housed in intake units with youth that are disposed to Department of Corrections custody. And we know that those kids that are disposed at the deepest end of the system and placed in these facilities are typically your more serious kids that have more felony offenses and more violent offenses. We also saw from the data that youth residing in smaller, more rural jurisdictions are more likely to be court ordered to receive this type of assessment in a facility, probably due to the challenges of obtaining that assessment in the community, the lack of providers and the availability of those diagnostic assessments, as well as the cost to counties if that assessment takes place outside of DOC. So obviously if the assessment takes place inside DOC, then that is not a cost that is assessed to the county. Of the overall number of commitments in 2019, 6% were a new commitment with a prior diagnostic. So a lot of kids that are admitted to Department of Corrections to receive the diagnostic don't actually stay. They receive another type of disposition, whether that's to residential placement or to formal probation supervision. And so they really are just in that facility for that short period of time to receive the diagnostic assessment. I'm actually going to go into the next key takeaway before I pause and share my screen, because the next takeaway is about policies and practices within the Department of Corrections. And I think that relates to the data that we see about who is admitted to DOC. And so the next key finding is that, or key takeaway, is that youth that are committed to Department of Corrections custody are not consistently receiving research-based or developmentally appropriate services and supports, in particular for reentry. And we'll talk a little bit more about what that transition process looks like for youth that are coming out of a facility. In examining policies and practices and speaking with stakeholders, we saw that the policies and practices are not fully aligned with what we know from the research works to reduce recidivism and improve outcomes. We heard from stakeholders that there's a potential need for more training on conducting the IAS risk assessment and the reassessment, and using that tool to inform the development of growth plans or case plans for kids while they're in a facility, to identify what their needs are and what they need to work on in the facility. We also heard from stakeholders that there's an increase in mental health needs in youth that are being admitted to Department of Corrections custody, and that as a result, facilities are struggling to provide those more intensive evidence-based programs to support those young people that have more intensive behavioral health needs. For the most part, facilities are not providing young people with post-secondary education or career tech education or workforce opportunities. When young people do complete their high school diploma or their equivalency, most often they don't have additional education or employment opportunities or skills that they can work on in the facility. And so they're left to either repeat programming or not be able to gain further workforce or educational skills. We also still see some sanctions-based policies and practices that are being employed by Department of Corrections that we know from the research have been deemed to be ineffective, such as the utilization of a boot camp program, as well as the use of segregation and isolation as a consequence to behavior. And we also saw that there are consequences at times for misbehavior that can include young people being removed from education and other programming, and that there isn't a formalized system of sanctions and incentives to address youth behavior and to reward positive youth behavior. That this may be happening, but not systematically and not in a formalized way. Additionally, and this is one of the biggest challenges that we heard probably from all of the stakeholder groups, all of the constituencies that we talked to throughout this process, is the lack of transitional or reentry support for youth that are released from Department of Corrections custody. Most often, youth are released directly into the community with no supervision and very minimal support. Post-commitment supervision or parole is only provided to a small number of youth for certain offenses. And then there are some counties where probation departments take over jurisdiction to supervise young people that are released from the Department of Corrections. But most young people are released directly into the community without any supervision or support. We also heard that reentry planning often begins just shortly before a youth is scheduled for release, rather than beginning reentry planning when a youth enters the facility, which can leave a small amount of time for Department of Corrections staff, family, and other stakeholders, including providers, to make the necessary connections for young people to continue their treatment or services in the community. Transition coordinators and facility staff work with young people to make those warm handoffs and connections. But we heard also that without any formal aftercare system or contracted services for youth upon reentry, that there can be a lack of follow through and accountability to make sure that young people are receiving treatment, they go to their appointments, they have transitional housing, transportation, et cetera. And we heard that from most stakeholders that this issue, the lack of transitional supports and reentry, such as housing, education, employment, or family-based therapy, is probably one of the biggest challenges that is impacting recidivism for those youth that are coming out of Department of Corrections custody. So I'm going to stop right there and stop sharing my screen and go back to the discussion. See if there are any immediate reactions from Senator Kreider, Representative McNamara, and then obviously would love to hear from Angie and others about their reactions to these findings and the data.
I'm also curious to see what the folks that work in the system have to say.
Yeah, exactly. Same thing.
I lost Angie on my screen. I don't know where.
I'm here, Nina.
She's there.
There
I'm here.
Go ahead, Angie.
I mean, looking at the data, I'm not surprised by any of it. I think it's things that we have been discussing. I've been in my current role for a year. I've been with the Department of Corrections since 2012. Terry's been in her role as the executive director for about 8 months. These are conversations that we're having, things that we're looking at. I think for us, some of the biggest challenges is what we do have to offer to kids. We can treat a kid in the Department of Corrections for mental health needs or mental health concerns. We even go as far now as to set up the kid's first mental health appointment when they leave us, but there's nothing that is requiring the parents to actually take them. If they're on medication while they're with us and we release them to the parent, there's nothing that's really holding the parent accountable for them to continue that medication or to continue to seek services. Like it said, very few kids are taken back on probation. We have guidelines that we follow to whether or not we put kids on parole. We've actually started talking about adding more kids to parole. If they are added to parole, that's how we have the ability to provide them services when they leave. But then again, I mean, all of that does cost money. So we can't provide that parole option to a lot of kids. Re-entry, I think for us, one of my current roles right now is working on reentry. I also work on finding residential facilities for our kids to go to who cannot return home. I think you would honestly be surprised at the amount of parents who choose to stop being a parent. The amount of parents who say, we don't want our kid back. And we have to find alternative places for them to go. I currently have a young man right now who he's already did his time with us. He's been sitting with us since March of this year, just trying to find him somewhere to live. All the residentials have denied him. We've staffed him for foster care. No one was interested. He's only 17. His dad is his legal guardian. His dad refuses to talk to us. So at this point, he's sitting in a correctional facility just because, in all honesty, nobody wants him. So, I mean, those are some of the challenges that we face. And in regards to services, I mean, I couldn't tell you how many days we spend just researching resources for our kids that are in the state. There isn't anything that says Voices offers this, this, and this, and will accept these kids and these kids and these kids. And this organization will work with kids in this county and this county. There's nothing like that. So what we're doing is we are literally just Googling mentors and services and different things that our kids could become involved in. And we're calling and we're asking for meetings and we're going out and touring these places. Getting to know people, just networking. I mean, we have seen things on billboards or on news somebody just sent me a news story that was on last night about some people that work with kids. So now I'm researching, I'm trying to hit them up through LinkedIn and they're not accepting my request, and I'm looking for them on Facebook so I can send a message to try to get more information as a possibility for our kids. So no, none of the data surprises me, and it's all stuff that that honestly we know is a struggle for us.
The good news is DOC is not what it used to be.
That
and
is
it
true.
is a pleasure to work with, and they are at the table and they are willing to listen and work. You know, one of the slides that I saw was concerning the assessments. My recollection of how that came about is that it was prohibitive for counties to do that geographically, time-wise, and DOC stepped up and we created this process. So which, you know, these were kids that were not getting out of detention. We didn't know what to do with them. We didn't have all the other options. And DOC really came to the rescue by having these really good assessments. So you know, they fixed a problem. Maybe we collectively created a slightly different problem, but they're at the table and I think certainly a significant contributor to the good that's happened. I think overall the DOC numbers for kids are drastically down. So that's good. My only observation is on the average length of stay, would really like to do, it doesn't surprise me. I think that's something we forecasted on JDAI as we kept out of detention and consequently out of DOC, the kids that didn't need to be there. The average length of stay would go up because rightly, wrongly, and you could drill down, the kids that were in there were kids that we didn't have other options for. So that doesn't surprise me. What does surprise me and what I would really like to see if we could do a next iteration, and maybe you know this, is the difference. You know, I assume that's based on the offense they're adjudicated for. And not the offense or offenses, the most serious of which the petition alleging delinquency is. So, you know, if the petition is attempted murder and there is a dispositional agreement for some admission agreement to something less, then that may contribute a little bit. I'm not excusing the misdemeanors or something like that, but I'd sure like to know that, because I think that wouldn't be too hard to do, and it would probably inform the next level of discussion and let us target some of our practices or policies or whatever that you all are inclined to do. But again, very helpful information.
I would like to add, and in regarding the length of stay, that length of stay is going to include from the time we received the youth into intake until the time that they were released. But we have some kids that are sitting with us, like the kid that I just mentioned, where we're trying to find somewhere for them to live. So we may be searching for 2 or 3 or 4 months to find a residential facility that will accept a kid. And so for some of those certain kids, their length of stay is going to appear to be, I mean, they were with us for that long, so that is their length of stay, but it doesn't take into consideration the amount of time that they had to sit while we tried to find them somewhere to live.
Yeah, can I wait? I wanted to say you are correct in everything that you say. I worked for the Juvenile Justice Task Force, restrictive placements of kids coming out. So we worked with the families for 6 months before the kid got released. And one of the toughest things to do was to convince the family to even go and see their kid. The relationship is so broken that, and now I'm speaking from experience also, my son was in prison for 3 years and I knew where he was at. I knew he was getting fed and he was like 19, 20, but because he was chaotic and he did things and I feared for his safety, when he got locked up and went to prison, I rested comfortably because I knew that he was safe. Now that's a bad thing to say. However, this is how many of our families feel because the kids are terrorizing their families, they're terrorizing their communities. And for 6 months or a year, however long that kid is locked up, that family feels like they're getting arrested. So going into the families' homes, talking with the families and convincing the families like, ma'am, you got to go see your son. You got to go see your son. So once we got there to see their kid, you know, it was rough just trying to get them to communicate. So, and I do agree also, when those kids get out, I strongly encourage that those kids finish their GED, because one of the most important things that they can do while they're locked up is to get their HSC high school diploma. Because when they come out, there's a high probability that they won't, even if they're on probation. So while they're in there, they need to take advantage of that. But one great thing that has come out in this over the years is that the HSE programs and all of the work programs that have been created for these kids when they come out, you give 12 seat hours, you can get assistance in this area, that area. Now, one problem is that when these kids get locked up in the county facility, their schools will have nothing ever to do with them again. And we talked about this at the DOE level. And for a lot of these kids, once they're locked up at the county, not the county, but the state level, they're not coming back to their high schools. Whether their high schools have alternative programs or not, they're not coming back. That's one of those big secrets that the administrators will tell you. We don't want these kids back. So the HSE programs within the past 5 years, as far as career opportunities are concerned, they're the best thing since sliced bread for our kids. So I just wanted to speak to the families as to one of the reasons why the families won't communicate with the kids and why a transition to restricted placement counseling 6 months ahead of time is really important as far as getting those families back together. So just wanted to.
And James, you're right. And you know, what we found is when we are releasing kids back to high school, typically, like you said, the school's done with them. They live in the school district, so they have to let them back in, but they funnel them right over to the alternative school program, right back with the kids that have gotten them in trouble. If the kid has had a change of heart, I went through about a 3-week period where I had a mom call me every single morning because her kid was refusing to go to school. And his only request was, I don't want to go back into alternative school. I want the chance to be in the high school and be a normal kid. And the school would not give him that opportunity. So to him, he just didn't want to go.
Right.
So,
well,
yeah.
The high schools, we have a pilot program, and I think Washington Township has a pilot program. It's called the GOT program, where kids who are struggling can get a chance to earn their HSE and still be a part kind of sort of the high school, but it gives that kid that connection of graduating from their school. And that's important because those kids don't have that connection once they're locked up at that level. And sometimes that's all that they need is to know, hey, I got a degree from a high school diploma from North Central or Warren Township. That connection in the past has been lost. And here's the other problem from an administrative perspective from the schools. For a long time, those schools, from an accountability perspective, they weren't getting any credit for those kids that got their GEDs, because once they went to DOC or someplace else, they weren't connected with the schools anymore. So it's a win-win or a lose-lose situation. I think if we can get the best of both worlds and still allow those kids to be connected to their schools somehow, that's a win for the community.
I think it feels like we're constantly in this role, but to acknowledge that likely if these kids are ending up in DOC's custody, certainly, you know, the challenges that Angie's articulating is what we hear from Department of Corrections administrators across the country, the complex needs, the kids with increased mental health issues, the family challenges, the placement challenges. But there are some very intentional policy decisions that states can choose to make or to not make. So, for example, you know, Nina mentioned the kids getting placed solely for the purposes of assessment. Most states have eliminated that practice. Understandably, counties might not have the resources, but whatever the costs are, providing those costs, even if it was state staff that can go around, that are stationed around the state in order to do those assessments in the community, is likely less expensive or certainly cost neutral compared to actually sort of placing a kid in a secure facility for 3 weeks to get that assessment. So I think that's kind of a policy choice and a resource creativity choice for this group to talk about. Kids placed on a misdemeanor offense, as Justice David said, there's likely other things that go into that youth background, but that's where the risk assessment information is useful to know that the majority of those kids are moderate risk, which means that they likely don't have an extensive history of violence or serious offenses. There are states like Texas, for example, that have said no kid can ever be placed in a secure facility based on a misdemeanor offense. There are other states that have created guidelines about risk level and offense, but that's kind of an intentional policy decision that states have made. I think Indiana, probably one of the few states we've ever seen across the country where the vast majority of kids get no formal reentry supports. Given that these are the highest risk kids, and we've talked about Indiana increasingly concerned about the highest risk kids, an intentional policy choice about saying, should those kids, not necessarily nobody wants sort of more Department of Corrections or system involvement in kids' lives, but should they at least have a minimum amount of time where they receive specific reentry services and supports to provide for that continuity of care? The fact that Angie's saying that she has to, search high and low for services and resources. Some states make that the county's responsibility in terms of providing those reentry services. Some states have mandated reentry councils at the local level, and the Department of Corrections works with local or regional reentry service councils to be able to identify reentry service resources. The fact that kids are having to wait months in placement, some states have created sort of high-risk case conferences that require agencies across systems, Department of Corrections, behavioral health, child welfare, to meet to talk about that case so that it's not just the Department of Corrections responsibility to find an appropriate placement for those youth, but it is really a whole state system kind of solution. So again, none of these are all complex problems, but I think it is important to continue to uplift. There are potential policy remedies for at least creating different kinds of practices. Doesn't necessarily make some of these challenges easier, but can put in place certain kinds of policies, supports, and services that could help prevent some of these challenges.
And the other
one thing I'd like to just mention, it was about 4 years ago, the Department of Child Services entered into an MOU with DOC that opened up our entire service array, including all facilities available that we have under contract, to the Department of Corrections. And we were staffing cases, those high-end cases, to give them service or give them our expertise, knowledge about what services could be available, particularly that needed those services post facility. So there is that going. It's not a formalized process by any means, other than the MOA that allows DOC to use any contracted services at their expense. We don't, they pay for their own services post-residential, but that's already available and has been available for quite some time.
Yeah, Don, and you are correct. And I do still staff some cases, but it's the money for us. We don't have the money to pay for services for every single kid that's leaving us. So I mean, if we had it available, I would love to have kids on receiving resources. But the way we are set up is that the kid has to be on parole in order to receive services, because that's how we pay for the services. So if a kid is not on parole, we don't have funds to pay for them to receive any services.
The other thing, just to note, to kind of drive the point home about why aftercare and reentry services is so important, or having this planning process, is that for a data point in 2019, about 30% of kids released from DOC custody are 18 or older. So these are kids that are probably not going back to their traditional school, not going back to their families, need stable housing, need employability skills, post-secondary education, careers where they can earn a living, childcare, all these types of issues, that these young people are being released into the community at 18 and older without any type of resources or supports to help them make that transition. So I just wanted to note that in terms of age, and we see even more kids that are 17, so kind of on that cusp of transitioning to independence, and that's why it's even more important that these young people are getting those supports.
And I think this is gonna be one major theme of this conversation for the task force to consider. As we'll talk about in the next section, there are significant state dollars being invested in juvenile justice services. The question is, how are those dollars being invested? And given some of the gaps that we've talked about, does Indiana wanna establish some policy requirements and match those policy requirements with allocated resources that can support it? And I think Angie brings up one, and this assessment brings up one key example of that, which is, should all kids leaving Department of Corrections custody and returning back to the community receive at least some minimum standard of services and supports? And if so, should dollars be used intentionally for that purpose? And so thinking about policy directives and intentional use of dollars behind potentially trying to support a gap in that way.
So I am going to share my screen. I did see a question, Emily, Andrew, that Nancy posed about the IAS. Great, thank you, Emily. In the chat, so the risk level for the risk assessment that we looked at was reported by or performed by DOC. So I'm assuming it's the IAS residential, right, Emily? Okay. All right, I am going to share my screen. We're going to go on to the next takeaway. So our next takeaway is focused on juvenile justice services that are funded by the state. And that state juvenile justice funding is used primarily for residential services with limited requirements around that funding, limited quality assurance protocols or data processes in place to ensure that those state dollars are being used most effectively. And again, to present some of the research and context around best practices in the delivery of services for youth in the juvenile justice system, we know that services should be focused or prioritized on the more moderate, higher risk youth, and that community-based services have been demonstrated by research as more effective than using residential. Using funding to support, require, or incentivize the use of research-based policies and practices, and developing a continuum of community-based alternatives to involvement in the system and to incarceration in the deepest end of the system. Making sure that young people are being matched to services that directly address their criminogenic and behavioral health needs, and making sure that when they are engaged in services that they're receiving the appropriate dosage. Using funding, procurement processes, quality assurance, and data collection to require or make sure that providers are adhering to research-based practices and that there's some accountability in terms of their effectiveness and improving youth outcomes, and evaluating service provider performance and making sure that we're using those evaluations to direct resources to those services that we know are effective. So as I mentioned in the takeaway, the biggest finding in this section was that in analyzing fiscal data from Department of Child Services, Juvenile Justice Services, that 80% of those service dollars are being spent on residential services and 20% are being spent on community-based services. In total, in 2019, the state spent nearly $113 million on juvenile justice services. Divided up, that's about $88 million for residential and only about $24 million for community-based services. And again, this is the largest pot of state funding for juvenile justice services. And just as a quick definition to help contextualize this information, residential placements here are those contracted by DCS and include placements to group homes, child caring institutions, and private secure facilities. It's also helpful as we look at residential services and how the state is spending dollars the $88 million for residential in 2019, it's important to recall some of the data that we presented initially at the last meeting around who is getting adjudicated and actually placed in these residential facilities. So looking back at our 12 counties that use the Quest case management system, in 2019, over 70% of youth adjudicated to residential placement, and that excludes Department of Corrections or detention, are youth that are assessed as low or moderate risk to reoffend. I do want to say there's one caveat, of course, with this data, is that we don't have risk information directly from DCS for youth in residential placement. And so this data from Quest counties includes all residential placements, not DOC or detention, but they could include placements that are not DCS funded. But I think in general, we see that from that data that kids that are placed out of home in residential treatment facilities are predominantly low and moderate risk. Most youth that are in residential placement through DCS are in a residential child caring institution, which is a facility where youth are placed to follow a treatment plan. They usually remain for more than 60 days. Some may also provide emergency shelter care, which is less than 60 days. Or they're placed in a privately run secure facility, which is a locked facility where young people are typically placed long-term. And to qualify for that placement, youth must have behaviors that are considered harmful to themselves or to others. And you can see on the right-hand side, the cost in 2019 of the various placement types that are being funded through DCS, with the two obvious largest buckets there, the child caring institution at $50 million and $29 million for private secure facilities. And while we saw referrals to the juvenile justice system decline pretty significantly in Indiana over the last several years, as well as the decline in detention and the use of Department of Corrections, the use of child care institutions and private secure facilities have not decreased to the same extent. And in fact, the use of child care institutions actually increased since 2016 by about 45 placements. So overall, about a 16% decline in the use. I'm sorry, that was private facilities that were increased by 45 placements. Colors are a little bit hard to read, and a 16% decline in child caring institutions. In looking at fiscal information for community-based services that are being funded through Department of Child Services, Juvenile Justice Services, we see that those services are more oriented for a child welfare population and less targeted towards addressing a juvenile justice population and addressing a young person's criminogenic needs. You can see here that more than half of the money that's being spent on community-based services as a whole in 2019 was spent on family or home-centered case management and coordination, which is typically more of a child welfare function. And that means that less than half of DCS dollars for community-based services were spent on the more typical juvenile justice community-based services that address the root causes of young people's delinquent behavior. This also may be in part due to the way that the services are identified or captured in the data. And you can see that, that caveat there on the bottom, the definition. But also, I think one of the reasons, and we said this in our preliminary assessment, in terms of why the services may be more oriented for child welfare populations, is that typically the way services are identified are through regional service councils who assess the needs of their particular communities. And then based on that assessment, they submit information to DCS about the services that are that could address the needs of their communities, and then providers respond to RFPs to address those needs. We also know, though, that the regional service councils, for the most part, across the state, don't include any representation from the juvenile justice system, from probation and other parts of the juvenile justice system. And therefore, those voices are not necessarily always included in identifying the needs that a juvenile population might have. Additionally, and we heard frequently from system stakeholders that youth have myriad needs. They have a lot of different needs when they're placed in residential treatment, and that there's a lack of services in the community to address their more intensive needs and the complex needs that they might have. And that can also result in more kids being placed in residential facilities if communities don't have the services, the more intensive services to address young people's needs. However, one thing to think about is, could state dollars be used in a more intentional way to address some of those challenges? We know that counties submit a general budget plan to DCS, but there aren't many requirements or policies around how those state dollars should be used based on the size of the county population, the risk level of their juvenile justice population or local resources. Currently, state juvenile justice funding through this pot of money can't be used for pre-arrest or pre-court diversion. There aren't many funding requirements or stipulations guiding counties on how to use those state dollars to make sure that resources are being used in a research-based way or most effectively, other than a general approval process for using residential placements, the least restrictive placement language. Counties also report that there are specific service challenge, particular service gaps in rural communities, or as I mentioned, a lack of more intensive behavioral health services in the community. However, the juvenile justice service dollars through the state is almost entirely discretionary, and there could be more efforts to coordinate those efforts at the state level to use those dollars more intentionally and creatively to address those challenges. Additionally, and this information was also included in our preliminary assessment report, is that there's a lack of formal quality assurance and data collection processes to help make sure that these state dollars are being used most effectively. Currently, state statute lacks requirements on how juvenile justice state funding for program and practices have to be used to be in a research-based way or to use evidence-based practices. While DCS has been striving to invest in more research-based programs and practices, most services are still geared towards the child welfare population, and a lot of providers aren't receiving the training or the guidance on best practices to address the unique needs of youth in the delinquency system. There are very limited quality assurance processes in place to assess whether youth are being matched most appropriately to services based on their risk and needs, how they're engaging with services, or if they're receiving the right dosage, how they're completing programs successfully, and whether those services are being implemented with fidelity to the research. And also, limited data is being collected to determine whether states and counties are actually using those services most effectively, what type of outcomes they're getting for those services. And therefore, the state is really unsure of how the over $100 million, $113 million in 2019, if that money is actually having any positive impact and the intended impact that I know DCS and others want those dollars to have. But right now, that data does not exist to really be able to evaluate the impact that that money is having on youth outcomes and on recidivism. So I'm going to stop there again and open it up for discussion, see if there's any reactions most immediately by Senator Kreider and Representative McNamara, and then turn it over to others.
Hitting buttons. I think, you know, when you look at some of the dollar amounts and percentage amounts being spent, I was trying to think, I can't remember my bill number, but several years ago had a bill to create the community corrections piece of it, specifically for juveniles, so that we'd put people with juvenile expertise on community corrections boards. And that intent behind that was to try to give these wraparound services to juveniles once they came back into the community. And then if you're looking at, was it nearly $90 million out of 114 that's spent on residential, that's kind of opposite, I think, of the way that our money should be spent in trying to keep kids out of the system. Those are just my two real quick glaring opinions or observations.
I can't think of anything that I would add to what Wendy just said. There may be reasons why the money in the past has been spent, and maybe because we don't really know a different way or a better way I'm curious to hear if there's any response from any of the agencies involved. But it does seem to be skewed based on the conversations that we've had in the past.
I guess I can start with some responses because the one part, and I'm sorry, but the court submits a budget to the DCS for services. I don't know that that happens. I don't know how that happens because they don't. There's where that information come from. I'd be curious a little bit more about that. But beyond that, excuse me. One of the things about the Regional Service Council is a decision was made back in 2008 that the juvenile court judges would represent the probation departments on the Regional Service Council with their knowledge and experience in juvenile court processes. So that was supposed to be the expertise that was brought to the Regional Service Councils. A year later, that law was amended to allow the judge to provide a proxy. And throughout the state, there are some chief probation officers in particular, that go to the Regional Service Councils and on behalf of the judge. So there has been a little bit more flexibility in that. So there is some. In addition to that, there's an opportunity for probation officers during the discussion, particularly about services, to be a part of the discussion, not as a voting member, but talk through those services. And we've opened that opportunity up in the last several years during those discussions. So there's a little bit more information provided juvenile justice to the Regional Service Councils when they start looking at services. But and the last point I'm going to make is there is a more intentional effort. There's been an intentional effort, particularly with a program called Family Preservation, to look at the child welfare side. But there's also a very intentional effort going on right now to look more at the delinquent side to get those more services that would look at recidivism and criminogenic factors. So there is that effort that's going on. So I don't want to minimize some of the progress that we've been making here at the department for the juvenile population or juvenile justice population.
And I think it's important just for folks, in case folks don't know how this works, which is DCS may contract for services, but it's up to counties about how those services are used and how the funding is used. And so just again, to kind of paint a comparison with other states, it's very rare in most states to have this kind of pool of essentially unrestricted dollars. What most other states have done with their state funding that goes to local juvenile justice systems is support counties around very specific practices and funding used for those practices. So again, kind of what I mentioned earlier is like policy requirements matched with funding support. So we talked at our last task force meeting about states that have like diversion block grants and some requirements around using those dollars to divert certain populations of kids. A number of Midwestern states, for example, like Ohio and Illinois, have created incentive-based funding formulas for counties, specifically to develop alternatives to detention and alternative to incarceration programs. And that the more counties reduce their out-of-home population, the more resources that they get for community-based services. Other states have created funding streams specifically to develop evidence-based, intensive community-based programs and practices, including behavioral health services. And have helped counties build kind of statewide capacity around evidence-based programs. So really states trying to be very intentional about directing dollars for specific research-based purposes and then matching policy requirements to go along with that, as opposed to just kind of having a general pool of funding that can be accessed in any way that counties choose. And just to connect it to the last conversation we were having, so for example, when Angie talks about not having sufficient resources to provide young people, who arguably some of the highest risk kids in the system, coming back to the community, that Indiana could make a policy choice to say every kid should get reentry services and supports. And out of this $113 million, 97% of which is state funding, we want X percent of those dollars or X amount of dollars to go to the Department of Corrections or to go to counties or to go to someone else to specifically support those reentry services.
And there are service standards for reentry for those kids that go back into the probation system that are available through service standards already. I really would like to hear from Judge Graham and her perspective on this. But you know, like I said, there are a lot of efforts now to be more intentional, particularly, you know, when you start talking about the research in the beginning. I mean, those fall in line certainly with FFPSA and the intentionality of dollars spent, those type of things. So again, I'll yield to Judge Graham.
Thanks, Don. A couple things that I would note. One, I agree that we spend far more money on residential placement than community-based services than we should. And one of the reasons I think we can identify for that discrepancy is many times those community-based services could be beneficial to kids before they get in the system. And by the time they get in the system, so much has happened. And sometimes it's such an egregious situation that we've already lost the family and everybody else for those community-based services. So that's one thing. If we could make them available before they enter the juvenile justice system, either through a CHINS case or a delinquency case, that'd be great. And sometimes that's working with the schools to get kids identified and services to them before they come into the system. And then I'm a huge proponent of quality assurance. You can have the best practices out there, and I think most judges in DCS and probation are looking for and using evidence-based practices whenever we can. But if you don't adhere to the model, it's useless, and it's really difficult to keep people trained and adhering to those models if there's not a way to monitor that. I think that's something that's very difficult. And right now we're in the big swoop of the implementation of the Families First Prevention Services Act, where we have QRT facilities. We've identified that we want our residential facilities to be quality facilities providing quality services, and that we're monitoring that very closely. Well, DOC is essentially a residential program. And if we think part of our requirements for QRTP residential placements is they have to provide 6 months of aftercare services, then we should be doing the same thing for the kids who are leaving DOC and having that accessible and the funds for that to be provided. So I concur with you on that too, Don. I mean, I think that's something we ought to be doing, even for the ones that are coming out and they're not minors anymore. There's got to be a better way, because then we find them 2 or 3 years later, they're in the adult criminal justice system. So, and I think, in that process that, we've been piloting that QRTP, well, we have the Department of Child Services doing what they call a CFTR. Everybody gets together and says, yeah, based upon all the things about this kid, they need residential placement. And then we think it's important to have an independent person assess that and say, okay, we concur with DCS. Yeah, they need a residential placement. And then it comes to the judge, and the judge says, yeah, that all seems right. I agree that should be a residential placement. Well, that's great. But for us judges, it's not that they need residential. Which one is the right one? Which one is actually going to provide what this particular child needs? And that's something I think that is distinctly lacking right now. There's, again, a lack of awareness over what is out there and available that would actually fit this particular child's needs or the family's needs. So, yeah, I mean, that's something that's problematic.
And I do think that there's an advantage on the JD side across the state with probation service consultants doing that, because they have more of the knowledge of the services. And one other thing I wanted to add is, when you look at those statistics, and they were statewide statistics, there are counties across the state of Indiana that do 50-50, where 50% of their dollars are spent on residential, 50% of their dollars are spent on community-based. So there are examples of counties around the state that don't have that 80% towards residential. They're actually looking at more community-based services, and they're using those more community-based services. So I don't want to say it's all bad across the state, because I see those data and those big dollar figures monthly as far as what's being spent where across the state of Indiana. So it's not all bad, and maybe there's some things we can look at in those counties to learn a little bit what they're doing in their processes to help further understand. And So anyway.
Nancy, I know you had your hand up for a little while.
Yes, so both on this set of slides and the previous set of slides, at the risk of sounding like a broken record to some of you, I feel very strongly I'd love to see this data broken down, particularly by race. And the proposal for moving toward using services and programming and community-based options instead of residential, fully support that. But we also have to make sure those programs are right for our youth of color. They are the ones who are disproportionately and disparately represented in both DOC commitments and in other out-of-home care options. And I've said this before, but programs and services that are evidence-based don't typically get there by having data on youth of color. They are typically normed on white populations. And so just focusing solely on evidence-based services or practices or something along those lines is not going to get to our youth of color, which has to be a focus. If we don't get our youth of color out of DOC facilities and out of residential placements, we're losing the game. We're losing the war. And so that would be and I think, Nina, I saw just a brief spoiler alert about the next set of slides around that, but I just wanted to, both in the last set and the set before, we need to be looking at those who are most impacted by these decisions that are being made.
And Nancy, just to quickly speak to that, obviously, again, not an easy challenge, but it is where if the state wants that to be a priority, the state can be intentional about putting dollars behind that. And so whether that's an emphasis not just on evidence programs, but on grassroots programs, on credible messengers, on life coaches, on building up pro-social supports and faith-based services. But that's, again, the matching of the policy requirements and the dollars with the vision that you all have and Indiana wants to have for its juvenile justice system. And the really good news is the dollars are there. It's just thinking about what the policy requirements are and do you want to use those dollars for those more intentional reasons.
Thank you, Josh. You're right. We have the ability to make that happen. Thank you.
Other thoughts, reactions on this set of slides? And as Nancy said, she's previewing kind of the next section, and it really is only just one slide, but we had thought about, do we include disproportionality slides through each section, but we also feel like it is a takeaway in and of itself, and it's really important to see it as such, that it is that important to talk about it directly, but happy to stay here if there are more comments or reactions about service dollars. Okay, so this is going to be a quick screen share, but I think a very important slide. And our last takeaway from the set of data, similar to the finding that we had in our initial presentation around disproportionality and referrals and adjudication, that Black youth in Indiana are disproportionately likely to be placed in secure detention, in DCS residential facilities, and in DOC custody compared to their white peers. So similar to last time, we calculated relative rate for the use of out-of-home placement. As a reminder, relative rate index provides a measure of disparity in outcomes for different race and ethnicities by comparing the rates at which each outcome occurs in the population of young people ages 10 to 17. And here, outcomes mean detention, DOC commitment, or DCS placement to a residential placement or like the RRs or the foster care. A relative rate index of 1 indicates no disparities. An index greater than 1 indicates the outcome occurs more frequently for that group, here Black or Hispanic youth. And a relative rate of less than 1 indicates that the outcome occurs less frequently. And so here you can see that Black youth are more than 2.5 times as likely as white youth to be detained, more than 3.5 times as likely to be committed to Department of Corrections custody, and more than twice as likely to be placed in a residential facility. And for Hispanic youth, you can see there's a very slight disparity for detention, where you see a relative rate of a little bit more than 1, but no disparity for detention there's a slight disparity in detention and no disparity for Hispanic youth when we look at DCS placement or Department of Corrections custody. And I think this is very in line with what we see in states and jurisdictions around the country, that the deeper you go into the juvenile justice system, typically the more disproportionality you have by the time you get to incarceration or the deepest end of the system in terms of commitment. Any reactions, thoughts on that data? Obviously, I don't think it's surprising to folks in this conversation. Again, we felt it was important and significant enough to mention it as its own section and not embed it into other sections, because often what we see is that if states and jurisdictions don't tackle the issue of disproportionality and disparities head on, it gets buried in all of the other reform efforts. And while we've seen the system shrink overall in Indiana and across the country, in terms of overall kids coming into the system, we haven't necessarily seen those efforts move the needle around disparities. Any initial thoughts or reactions? Senator Kreider, Representative McNamara, others? Thanks, Nancy. That's a really important point. Making sure that if you do address disparities head on, then you are impacting outcomes for all kids. But if you don't, you're not going to get the outcomes for every kid that's involved.
It's also where the importance of data collection is so important, because Indiana doesn't know what it doesn't know. So, Judge Graham brought up what's the right residential facilities. Well, one answer to that is which ones are more effective. And there isn't data on that. Nancy brought up the point about services, which services are more effective for which populations. Are kids being matched to the right services? Are kids of color being matched to services at all? Or, more treatment-oriented services? There's no systematic data being collected. And so one of the priorities, not just for this group to think about in terms of policy requirements and dollars, but certainly I know something Rep. McNamara has been championing, and one of the reasons why she wanted to prioritize this effort in the first place was what kind of data should the state commit to collect and require providers to collect and require counties to collect and report, so that Indiana can say for $100 million, $115 million, here's what we're getting in terms of equity and outcomes.
Are you able to tell, is the relative rate index being calculated based upon the general population in Indiana, or is it based upon the population that enters the system? Because, police can't control who calls and says 911, come here, or we've got a problem. And there's decision points along the way. So where's the top of the funnel, I guess, to keep this in perspective? I've always, and in discussing that, I think in Indiana, we've always had difficulty keeping data on the number of arrests. Because if you have just, if the law enforcement officer just encounters somebody on the sidewalk and stops and asks a couple of questions, is that considered an arrest? And is there any data on it? Because I don't know that our law enforcement keeps a lot of data with respect to maybe an arrest that never gets processed through the prosecutor's office. So how did we define arrest for this purpose, or was that part of the calculation at all?
So for this particular measure, we did use youth population age 10 to 17 in Indiana. So this relative rate is the cumulative or absolute disparity based on population, and it does not account for how many youth are entering the system. And you're right, like the widest disparity we usually see is at the front end of the system, and then we usually see that disparity widen as youth move deeper into the system. But this particular measure is only looking at that absolute disparity and not any individual decision point within the system.
And to your point around arrest data, I think that's one of the gaps in the data when we, just looking back at our last presentation, not having any statewide data around arrests or referrals to the system. I think the only statewide data that is captured by an individual counties in the probation department is like the intake, but not kind of the point of arrest or that initial contact. So that is one of the biggest gaps in the data. Any other questions, comments, reactions before we move on to a few next steps? So we do want to share, and we already actually started talking a lot about some of these questions for consideration, that the task force, that our working groups are starting to focus on as they begin to think about potential recommendations for improvement that will be before the task force at the next meeting. So some questions for you all to think about, and some questions that the working groups will be tackling around potential solutions. What are the policies and practices needed to ensure that services and the use of out-of-home placement are prioritized for the highest risk youth? How can resources in Indiana be allocated and used in a more intentional way to support diversion and other alternatives to detention and out-of-home placement? How can the state establish a more consistent and equitable approach to detention and the use of out-of-home placement at a statewide level, while also maintaining county flexibility and innovation? And how can the state use the significant investment that it makes in juvenile justice services, over $100 million, in a more intentional, cost-efficient way to match kids with the right level, type, and quality of services? And I know we began that discussion today. The working groups are going to be diving deeper into these questions. And then as you'll see in a couple slides when we talk about next steps, that'll be before the task force at the November meeting. We also just wanted to provide a few examples to get the working groups and to get you all started in answering those kinds of questions, some examples of how other states have addressed similar challenges that we identified and talked about today in this set of findings. And I know that Josh and others have mentioned some of these examples throughout our conversation, requiring the use of decision-making tools such as detention screening tools and risk and needs assessment to guide decisions around detention and disposition, having statutory limitations around the use of detention and incarceration and making sure they are only being used for public safety reasons, eliminating the use of out-of-home placement as a sanction responsive to technical violations of probation or for diagnostic purposes, requiring that state dollars be used for evidence-based or promising-based practices, establishing grants or funding formulas that require and support diversion efforts and the use of evidence-based programs so that the state can build a more robust continuum of community-based alternatives to the use of out-of-home placement, as well as conducting more quality assurance assessments and having oversight around the way those service dollars are being spent, establishing performance measures for service providers, and ensuring quality improvement processes are in place for those providers being contracted for services. In terms of next steps, we have the 3 working groups that are currently operational. One is on the front end of the system, one is on the use of out-of-home placement, and one is on service dollars and service provision and quality assurance. The working groups have met 1 or 2 times. They're going to continue to meet again starting next week to dive deeper into the assessment data, but also to begin really diving into and developing formal policy and practice recommendations for the task force. As they work through those recommendations, they will be vetted with additional stakeholders beyond the working groups and beyond the task force. We're going to be asking working group members to share recommendations with their peers across constituencies to see how they work in practice, to see how supportive folks might be of those recommendations. And then those recommendations will be shared with the task force chairs and task force members ahead of our November meeting so that you all have time to react, provide comments, and respond to those recommendations before we actually meet as a group to deliberate those recommendations. Those recommendations will be presented to the task force on November 29th, upon which the task force will determine what the legislative priorities are for this upcoming session coming out of this assessment process. Just as a reminder, that meeting in November on the 29th is a full day meeting. And so we really want to emphasize that your attendance, the active participation of everyone on the task force is really important, because that is the final meeting in terms of this phase of the process where recommendations will be deliberated and decisions will be made about what to move forward on for legislation. I know we are still going to discuss how that meeting will take place. I think it would be ideal for that meeting to take place in person, given the length of time and given the need for folks to be around the table to really hash out and discuss the recommendations. Obviously, we'll see what the world looks like, but I think that is ultimately the goal for that conversation. Any other thoughts in terms of next steps? Josh, Emily, Steph, that I missed? I also want to obviously turn it over to our chairs as well for their remarks. Representative McNamara, Senator Kreider.
On the 29th, if you don't know if you'll be available, please let Nina or Josh know. It's critical to have everybody there so that we can have a robust conversation over what the priorities would be. I can also, reserve the House chamber. That'll give us lots of space if that's something we're looking for, so that you're not concerned about being in a tight quarter of one place or another. So that's always an option. But again, thank you guys for your service on this committee and task force, and thank you to CSG for drilling down the information for us.
I just want to add my thanks to everyone that's involved. At times, this conversation just is kind of heartbreaking to listen to, but at the same time, I'm encouraged that we now, or at least I now know much more about the challenge that we have than I did prior to us starting this project. And so to the extent that you've participated and provided your professional expertise, I appreciate that. I think the information is power, and so I'm hopeful that we will come out of this project with some strong policy recommendations, and Indiana will join the other states that have gone through this type of project and move their juvenile justice system forward in a way that really does serve the population that we're trying to take care of. And so it's been a real learning experience thus far. I'm looking forward to the continued conversations, and particularly the day where we distill that down into a final recommendation for legislative action and for other action. So thank you for your work.
Thank you, everyone. I want to echo those comments. We really appreciate your leadership, Senator Kreider and Representative McNamara, and everyone's participation, the transparency, all of the focus groups and interviews. We really had a lot of folks really interested in participating in this process. again, this presentation and the live stream recording will be on the Commission's website. We do want to encourage folks to share that with your peers and with your colleagues. I think it's important to get that information out there so folks are aware of the findings. And obviously, as we get to the recommendations phase, for you to have those discussions with your colleagues, I think will be really critical to moving those recommendations forward. So thank you all so much for your time over two and a half hours or so that we've spent together this afternoon. Really appreciate it. Have a great weekend, and we will be in touch shortly around next steps. And again, as Representative McNamara said, if you can't be there on the 29th of November, please let us know. I'll also send an email out so the folks that are not currently on this call know about that importance as well. Thank you all.